Here, we're actually starting on time. We welcome Dana back. Glad she is here. Life is somewhat normal, so not that we didn't appreciate those that tried to help, but uh, Dana makes sure we're running in the right direction instead of south. Okay, so we're going to first do bill introductions. His last day for that. We call on Rebecca Schmoy. Representative Schmoy, sorry about that.
That's all right. Thank you very much, Chairman. I am introducing 24 RS 2947 on behalf of the Kansas Honey Producers Association as well as the Northeast Kansas Beekeeper Association. This is regarding allowing beekeepers who meet certain requirements to sell packaged honey and honeycomb without holding a food establishment or food processing plant license.
Okay, any questions? Seeing none, bill is introduced. Thank you.
Thank you.
Any other bill introductions? That's all I'm aware of. Okay. Well, as you found that probably in the emails that we do not have a presentation from Hilmar today, but we're working on another date for them to come and to give us an update on what's going on there in Dodge City and moving forward. So as Coach Reed says, this time is yours. I just felt on Thursday after the hearing, there were still questions. I'm not overly comfortable yet, and so I'm assuming that everybody else has my level of want to make sure we get this right. This bill is a heavier lift maybe than what some of us thought it was going to be, and there's a lot of things in there. So we have asked the conferees to come back that testified. So you could, if you want, we can call them by name. We can do whatever you want, or conferees, if there's something that you might be better to discuss. And if you have the bill with you to discuss, that will be great. I forgot it, so I'll have to pull it up online. So yes. So it is House Bill 2607. Again, this is not a formal hearing, so we will just start with questions or any comments that any of the committee members have. So who's up first? Representative Gardner? You touched your mic, buddy. You're on. Are you ready, or you want to? Okay.
Thank you, Mr. Chairman. I was listened to. I was tardy last meeting, but I listened to it all online, and I am a private applicator, and so I have considerable experience with this whole issue of a private applicator's license to apply restricted use pesticides, and also the value of that in being able to apply that to property that belong to neighbors, because I'm a ranchette owner and I have ranchette neighbors. I'm the one who owns the equipment and I have the training to control things like musk thistle and Sericea lespedeza, and so that's important to me, that we would preserve that ability if at all possible, because in practical terms it does help in the control of these problems, particularly as we get into areas where we have smaller acreages. For instance, my neighbor has 9 acres. Another neighbor has 6. Another neighbor has about 35 acres. And none of them are, they all participate in agriculture, but to a very, very limited basis. And I'm the one that helps get the neighborhood musk thistle and Sericea lespedeza and invasive species under control. And so that's very important to me that we preserve that. And the penalties assessed, I agreed with Randy Stuckey's assessment that, you know, it worries me when we put it into law that a regulator could drive into my driveway and assess a $5,000 penalty per day per violation. Even though I don't purposefully violate laws, it's getting increasingly difficult to follow every last piece of that, particularly the record keeping and following all the label things on each product. And I guess that's an excuse, but I also want to bring to the table the fact that we have made, in my lifetime, which has been quite a while, we've made tremendous progress at getting these pesticides under control and applied properly and safely and effectively. And the private applicator license move has been a good one to really help with that. And this law, the way we have it written, causes me concern with the penalties and the restrictions that we may lose ground at controlling these problems, particularly as we get into areas where we have small producers and landowners who don't have a very large amount of real estate. So those were my comments, and that I would definitely support some changes, but am not opposed to the Department of Agriculture regulating and controlling these things as they have in the past.
Okay. Representative Blex?
Thank you, Mr. Chair. I have to ditto my fellow colleagues' analysis. I feel about the same way. He said it more eloquently. I'd have said it faster, but he does a good job with that. I mean, I feel exactly, in my prior world, I was kind of the go-to guy, and we dealt with a lot of these chemicals and noxious weeds, and I see that, and even going to church, somebody will ask me about controlling Sericea lespedeza and what do you need to do and all that. So I do feel like the same way. This puts an undue restriction of record keeping, and most of us in the room that do it are smart enough to know if it's wind or is too high, you don't apply. I'm not much on broadcast spraying. I usually do spot spraying on my pastures to eliminate the problem ones and save the lead plant and those. But I think there's too much record keeping, and its fines are too much. And I would have to agree 100% with my colleague that this thing isn't quite ready for prime time, in my opinion, even though I know we were getting pushed by EPA and under that supposed deadline. And I know the consequences, having worked in that field, know that if you can't do your job at state level, the feds love to come in sometimes and take over. And we certainly don't want that. And that would be a disaster. But I think we need to maybe revisit certainly the private applicator. I have no problem with the commercial issue. That's been around enough, and people that's in the business making money, they know that. And those changes in labels, even though slightly, I assume sometimes, maybe wrong, but it's because I've done it for 10 years, I know, but there may be a label change that could catch me of being a violator. So I am concerned, have the similar concerns, and right now, as the way it's written, I probably am not going to be a super supporter of it, because I'm old enough to remember even the M44s sodium cyanide that we had a question on, that the coyote getters, that, you know, you put a little metal canister out, you set it down in the ground, and you insert a blank kind of 38 cartridge and put a cyanide pellet on it and put a spring thing that comes down. Well, first of all, you put the fur over it and a little bit of lure, and it's a non-discriminatory. It's very effective on coyotes, and the coyote comes up and bites that and pulls it up, and the cyanide capsule goes off in his mouth, and you find the results not too far away, 25 yards. Hey, we used to have to post signs that saying these was a cyanide there, and hopefully we had somebody that could read from southeast Kansas and wouldn't get hurt. But anyhow, I've seen a lot of changes, and we've seen a lot of restrictions, and we don't use that kind of stuff anymore. And that's good. So I don't want to see us going overboard, and I think kind of the EPA kind of tends us to push us overboard. So maybe I have taken as long as my fellow representatives. I apologize for that. Thank you.
Twice as many words, but just as, how about, no, it's fine. Now, before we go into more questions, I do want to give conferees the opportunity to respond. I do want KDA, Kelly, or whoever wants to come forward, and what you've heard, you know, again, a lot of discussion about private applicators and, you know, the concerns of the committee so far. What does the KDA then, you know, say on these?
Thank you. Kelsey Olson, Kansas Department of Agriculture. I appreciate your comments, members. I would point out that the record keeping for private applicators is not to the degree that it is for commercial applicators throughout the bill. It would only be based upon whether or not that restricted use product requires record keeping. Our dicamba products today do require record keeping, and that is a label change that has come in the last couple years. So I would note that for private applicators, our record keeping is not to the same level of the commercial applicators. And in regards to the fines, I know we've had several conversations. It's been brought up already about the fines and the language that's in the bill. I'll be honest, as we've tried to craft the statutes that comply with the EPA's rules, we have not built out our proposed regulations for private applicators for a penalty matrix. That's something that we have to think through, and this is I would say that it does give us some broader authority than we would likely apply in real life situations, but we have not built that policy matrix out for the private applicator component. We do have a matrix that we have been utilizing for the commercial side of the industry for a number of years. In recent history, Kelly and I were talking, we can think of a time when there was someone who made 96 violations, and that person was fined $4,000. So even though there is a compounding component to it, we have set ourselves a very high bar in order to get to that. Right or wrong, that you may or may not agree with the 96 violations that only stopped at 4,000. So I'd like to think that we'll be able to develop a policy matrix that would be considerate for the private applicator as well, but that is a component that is not yet developed at this time.
Representative Minix.
Thank you, Mr. Chairman. Kelsey, I was home over the weekend and had comments from a lot of ag producers. Someone asked the other day in committee they'd like to hear from real farmers. We have a little tank sprayer on the back of a side-by-side. We go out and spot spray bindweed in fields or pastures or whatever we need to. We've got a tall spray coop that we put foam chemical soaked boom basically to go out and work through shatterkeen on milo fields. Those are not inexpensive. I rigged up my sprayer to do that, and my neighbors would like to have me come do theirs. I hate to tell them that I can't do that because I can't barter anymore. The same thing with our big sprayer. I work with a local neighbor. He harvests and picks some of my corn, and I spray some of his wheat stubble when he's busy with other things, and he picks corn for me. It's been a really good working relationship. I hate to see private applicators be held to the same standards quite as the commercial applicators, and there really doesn't anything in there for size. I know some private applicators that are huge, hundreds of thousands of acres. I would far prefer to see something higher fines when someone does cause a problem. I've never been turned in or had a complaint on my operation. I have a pesticide applicator's license, my son does, and one of my hired men does. And we do it as well as possible. My mix station would meet the commercial standards. And I hate to be penalized, a closed book test, higher fines, this and that. I don't really mind the fines for those people that violate something. I think they're the people we need to concentrate on, and not the general public out here that's actually doing a very good, responsible job.
Comment?
Yeah, certainly. Thank you. I too share your similar story, and have a backpack sprayer that I use myself on our own farm. And I would say in our discussions, we have indicated to the chairman that we would be open to the, I don't know how to say it, unstriking of the language when it comes to the bar for the trading of services, because we do see that that's a valuable element that many of our producers engage upon. And so that's certainly something that we would be viewed as a friendly amendment, unedit, however you phrase that, as something to change.
Representative Blex?
Mr. Chair, for a second time. And I feel like the Kansas Department of Ag has noxious weed laws that we are mandated to control. I mean, that's your mandate, and kind of what in some cases seems like you're kind of tying the hands to encourage people to do that because you're making it overly restrictive to, I can't afford to do that, and I really don't have enough to hire a commercial rig. And I don't know about in other parts of the country, but when it gets busy, you can't hardly find a commercial outfit to service even your ag crops, your big fields, let alone some small acreage. I mean, it's like a month lead time sometimes to get people there. And of course, you get into the lack of timeliness in spraying, you've lost your edge. You know, when moisture's coming up in the plant, you need to be able to spray it, not, you know, it's like what we went through in southeast Kansas. It's been 2 years of drought, and really there has been very little ceresia spraying just simply because of lack of moisture uptake, and the chemicals wouldn't work. So you're kind of requiring one set, this is the law, and yet you're trying, you know, this, what's proposing is kind of tying the hands of people to be able to be in compliance with noxious weed laws. Thank you.
Can you comment on that?
I appreciate your remarks, and would say that yes, there are many aspects of the regulatory industry that the agency administers, and we do oversee the noxious weed laws. So there are requirements out there if you have a noxious weed that you're supposed to require that controlling that. I don't know that I can speak to exactly what products are going to be used on all of those noxious weeds, but we are specifically talking about restricted use pesticides in regards to this bill. There might be over-the-counter, non-regulated products that you can still control in some of those situations.
Representative Seibert?
Thank you, Mr. Chair. A very interesting conversation, and a follow-up on a question from my esteemed colleague beside me. If a township asks the farmer to come and maybe spray some bindweed or Johnson grass in the ditches and he doesn't have that pesticide license, or he does that mean that he's liable for anything like that, if, you know, if we're trying to help the township out?
An individual or the township employee?
Most farmers are pretty good about helping the township. Some are on the township board, you know, so if it's on the township board, and just like my neighbor helps his neighbor, and they call you because we all got the side-by-sides, or, you know, we got gators. We've tried to buy John Deere.
So you're saying the farmer's liability to help, say, on the county or township road? Is
Not
that
the county, because the county gets real,
right,
they
okay.
don't like that. But
Right.
the townships are usually pretty compatible with it. Does that fine and penalties go on then if you're doing that? I mean, what's the liability on that?
I might defer to our program manager, Kelly Novinsky-Wenzel, to get into the weeds on that a little bit.
Good afternoon, Mr. Chairman and members of the committee. My name is Kelly Novinsky-Wenzel, and I am the Pesticide and Fertilizer Program Manager with KDA. And with respect to your what-ifs, there's always some extra factual components. But in this situation, a pesticide business license is required when you're making pesticide applications for compensation on another person's property. And one of the things that we've been seeing lately is folks that are trying to help the county or the township, and the county or the township may or may not necessarily want the help, because in those situations, it can drift onto a neighbor's property, and then there's the question of who is actually liable for that. In the situation where the township would be contracting with an individual and providing them compensation, that business license would be required.
Okay. All right. Representative Minix?
I guess I need to make very clear, I would like the Kansas Department of Ag to retain primacy on this issue, but I would really like to see some things amended on the current bill, like ability to barter and maybe a discussion about the fines before I'd like to see it move forward. And then I'm guessing you would need to send that revised plan to the EPA and see if they would accept it.
So what we're proposing at this time is having discussions. I think that you'll hear from some other conferees as well today. But with respect to our plan, it has been approved by the Environmental Protection Agency. And so as part of our plan, there's an implementation timeline written within that. If we are to go outside of that implementation timeline, we would have to go back to EPA and have a conversation with them about what that would look like for a plan modification.
Thank you.
I won't forget you. Go ahead.
Thank you again. So just for clarification, if you help your township or your neighbor, like it's been brought up, and you don't charge anything for it, he provides the chemicals, you just provide the equipment, is you liable? Or is it only if you kill something on somebody else's property that said they don't want it? But, you know, is that what the liability factor comes in, is not just you spraying it, but killing something on somebody else's by drift?
We look at a variety of different factors, licensing being one of them. Another key component of our law is, was there a violation of the pesticide product label? And so when it comes to kind of liability per se, if it's a civil discussion, that is outside the scope of KDA, because again, we're looking at, was the Kansas pesticide law violated? And so in situations where there's an individual helping, not necessarily for compensation, that could fall outside the scope of the underlying requirements. A lot of times with respect to general use pesticides as well, you don't have to have licensing in order to make those pesticide applications. You can go into, you know, a Tractor Supply and buy Roundup for your dandelions, and that does not require a license through us.
So if you have a problem with these problems on the right-of-way for a county or highway, and you call them and they don't spray them, is there somewhere you can call them so they do spray them so we get rid of these noxious weeds then? Because they're not doing it. Like some townships won't do it no more because of liability. But, you know, I can show you pictures of Johnson grass for miles on the county roads now.
So I would defer to our plant protection program. That's not necessarily within my purview of my program. The noxious weeds law is outside of my scope. I apologize. I think that's something that we could work with to get you an answer as to who best to call.
Looks like maybe we'll have somebody from Noxious Weeds come over after turnaround. Madam Sister. Representative Shiggins-Sleeben. No, I messed up.
Thank you, sir.
Close enough, right, for a Monday? All right, go ahead.
Okay, help me understand this a little bit. So since we are down in the weeds, I'm going to come out of the weeds just a little bit, and I'm sorry, but, you know, it fits. So when you're dealing with the EPA and you create a plan that responds to this particular issue, do you make suggestions to them and then they approve your suggestions, or do they say, this is what we want and you need to comply with this?
In this situation, the EPA created a rule that was very specific in a lot of components, and that was before me in this role, so I will start by saying that. However, you must meet our requirements, and we're not going to approve your plan until we believe your plan meets these requirements. So there was lots of internal discussion between myself and EPA to try and see what we're proposing, if that would meet EPA's requirements, in order for us to get that plan approval by that November 4th, 2023 deadline.
So is there room for some of the modifications, if I can follow up? Is there room for discussing some of those modifications that have been suggested anyway? Or does that just throw everything completely off course? Or are these things that can be modified and still come within the criteria?
I think the answer is it depends on what the requirement is. So for example, EPA has set those minimums. That would be things like the closed book exam for private applicators. Our kind of counter proposal to that is to try and find workarounds where we've proposed initial training, recognizing that maybe not everybody's a good test taker, so maybe training is a viable option. And that's how we've kind of been able to try and work around those requirements. If it's something that does not meet EPA's minimum requirement, we will be having an ongoing conversation with EPA about the status of KDA's primacy in the state.
So just to put a point on it, are we in trouble here if we take some time to, I mean, is it possible to sort of quickly encompass the criticism and figure out how to modify this so we have something at least?
I cannot unfortunately speak to what EPA will or won't do. I can't speak to what their timeline looks like. What I can speak to is we have a proposed implementation timeline within our plan. We know that EPA will be checking to determine if we're trying to comply with that implementation timeline.
But we have till November.
No, we had to have plan approval by November 4th of 2023, which we obtained. This is that first next step. What we had proposed is trying to work towards an implementation in January. Because of how our implementation rolls out, we won't get folks all the way certified until January 31 of 2031. And I think the longer we push that out, the more concerning it becomes.
Thank you. Thank you, Mr. Chair.
All right, clear as mud. Representative Mosier.
Thank you, Mr. Chair. Kelly, I think this question's for you. I had a question about the liability insurance taking the place of surety bonds, letters of credit, escrow, those kind of things. Can you speak to why the department will now just recognize the liability insurance instead of these other avenues?
Yes. So back in 2020, KDA pursued that House Bill 2463, and that was when we initially proposed eliminating the other proofs of financial responsibility and leaving in place that insurance liability only. This goes back to that bill and what KDA was proposing at that time. We thought it was a good clarification. We still believe it's a good clarification. And looking at our businesses in 2023, we had 1,566 businesses that carried insurance. We had 48 that carried a letter of credit, 19 that carried a surety bond, and 3 that carried an escrow account. So we do believe that there's more interest in those other components. The other key piece to this is that there's a difference in minimums between insurance and with those other proofs of financial responsibility. So per statute, you're looking at a $6,000 requirement, whereas when it comes to insurance, it's the $25,000 for bodily injury and $5,000 for property damage. So there's a significant difference in those requirements as well.
Thank you. Thank you, Mr. Chair.
Representative Blex.
Thank you again, Chairman, for multiple times. One of the concerns that I've had brought to my attention is the lack of testing facilities. It seems dang near impossible to find a place. It used to be K-State Extension. You used to be able to get your pesticide examination, and it was readily available. I mean, if you missed a date, you didn't have to worry another 6 months, there'd be another testing date. And now it seems darn near impossible to find any kind of a location. I've had complaints people can't get access to renew their their license, and obviously, what's the status on that? I mean,
Are you, if I can clarify, are you speaking towards private applicators or
yes, private
commercial
applicators primarily.
Private applicators can go into research and extension currently, and that is where they can take an open book exam. There's also opportunities for them to take it online for renewals. One of the things that we're looking at moving forward is trying to get an online exam proctor as well, because we recognize that that is something that's important while still partnering with our folks at K-State, because we do recognize that not everybody likes the online testing. So that is available for folks. If there's a specific county or concern, I'd be happy to speak with you about that.
Thank you for that. Now, so you made a statement they're going to closed book. Is that correct?
That is correct.
So is that going to cause more of this problem of issues of getting people to test? I mean, sounds like to me it would.
That's why we're looking at an online system where it's like an external proctor, so it will not be an issue. So any folks with a laptop that has a camera would be able to go online and take it. That's something that we're actively exploring at this time.
Okay. Thank you. Thank you, Mr. Chair.
Representative Roth?
Just a comment. It seems like to me that this was developed without the input that you're getting today, this whole bill. And I have to agree, I'm not a farmer, rancher. I got 3 acres with a 1 acre garden. And so I don't like anything that could punish small business operations. And small farms and small ranches are small business operations. And I don't like an undue burden put upon them or a fear of getting exorbitant fines that would actually put them out of business potentially. I'm not saying that you would or you could, but once this goes into law, then there's a possibility. And then we've said that, well, we don't know for sure what EPA is going to do. So you know that you have something from them, and then this was developed, and now it's brought to us, and now we're getting information that probably you should have got before you made the plan. And so I'm going to agree with my colleagues here that there needs to be some changes to this to protect the private applicators before I think I would even consider supporting it. So thank you for letting me speak, Chairman.
All right. Representative Hsu.
Thank you, Mr. Chair. Just thinking out loud to the committee more than anything, you know, it seems like probably, I don't know, 60, 70% of this, most of us are probably okay with. Is it helpful at all from a timeline perspective? Can we just, you know, amend out the stuff that is controversial or still needs discussion? We can move through something to get the timeline rolling, and then we can continue to have discussions and hammer out the remaining details. Is that even helpful to you, or is this something that we should just take some time and hammer it out and just slow down, you know, and get the whole package right?
With respect to components like civil penalty authority, that is something that EPA has asked us to have in our bill. The amounts were not specified. I know that that's a question we've been receiving. I think that myself and other conferees, I would defer to them to have an opportunity to speak on that piece as well. With respect to amendments, I think it truly depends on what pieces are being amended out, which will depend on how my conversation with EPA looks.
Okay. All right. Representative Jacobs?
Thank you, Mr. Chair. Thank you. Has there been any conversations about challenging the EPA and in my opinion, their overreach in the 10th Amendment? Has there been any challenge saying, no, we're not going to comply with these issues? It's not the federal government that has made the states. It's the states that have made the federal government. The federal government should not have the ability to dictate everything that goes on in our lives. There has to be a point and a time where we just say, no, we're not going to comply. And has there been a conversation challenging the EPA in this matter?
To the best of my knowledge, no state certifying authority, which would include states, tribes, territories, have brought that up. What I can say is there's 67 certifying authorities that have their plans that were approved. So I can't speak to whether or not there were outside folks or other issues that tried to address it that way.
Go ahead. Thank you, Mr. Chair. And I also have concern, as my colleagues, with the private applicator. Again, government getting larger and larger and larger. Most of us know how the process works, even with budgets. They come in wanting more money, and we give more tax cuts to big business, and then it's the little guy who's paying for that after they, but anyway, that's a rant. Anyway, the fines. There's no way in good conscience that I would be able to even apply my signature to this without knowing what the true repercussions are. So with that, so I would like to see some things in writing first and not just give it up to the agency and say, you tell us what you, I think there's been some mistakes going on in government. It's not really, again, the agents that tell us what to do. We tell them what to do. The agents work for us, for we the people. And this is the concern. Government is getting way too big, and we comply and we comply. And again, I know I'm beating a dead horse to glue, but when are we going to stop complying and just say no more? We rule our own, and that's it. Thank you, Mr. Chair.
Okay, thank you. Representative Carlin.
Thank you, Mr. Chair. I apologize. I was out of town and missed this discussion, but I think I get it pretty well what's going on. I have a question, procedural. If we pass a bill that satisfies Kansas, that we all can agree on, and then how will we know if they don't like it at the federal level? What's the process?
I believe the initial conversation would be with me through our project officer, because that is, we at KDA, the Pesticide and Fertilizer Program, is what holds a cooperative agreement between KDA and EPA. And so that's where that conversation would most likely start.
So you'd have to take the heat. So, but is that a possibility that we could offer what Kansas would prefer and then work back and forth at that? Is that the way we negotiate with the federal government on something like this? I don't know.
In this instance, I think we have tried to do our best to have those negotiations ongoing with EPA and proposing a plan that what we believe does meet the needs of Kansas. I understand that there are some concerns with what you folks are seeing before you today. I think that we've had that good faith conversation with EPA, and we're going to continue to have those good faith conversations with EPA.
Representative Murphy.
Well, thank you, Chair. I would just kind of ditto with some of the stuff that's been talked about as far as the private thing, and in relation to to Representative Jacobs, there is a case in front of SCOTUS right now that may knock back some of the federal agency stuff. We won't know till this summer, but at least there's something going on that may give us some relief.
We're going to call on Revisor Hamilton. Boy, if anybody can help with explanations, and your question's got to be riveting, I hope. Enlightening, maybe?
We'll find out.
Yeah.
Thank you, Mr. Chairman. So I'm Kyle Hamilton with the Revisor's Office, and I do wonder if it could be helpful for the department to maybe put together a document that delineates the changes in the bill, what is required or what is a need for the state to retain its state certification plan with the EPA, and then changes that are made in the bill that are maybe more preferential or wants. I was quickly just trying to look through, some of the applicable federal statutes, and I found one. It's the definition section, one of the authorizing statutes for the federal regulations we've been talking about, and it defines private applicator in a way that mirrors what the Kansas state law currently says, where it includes applications on the property of another person if applied without compensation other than trading of personal services between producers. And so then seeing that change in the current bill at the state level that crosses that language out, that raises the question of, well, is that something that needed to be changed for the state to retain EPA certification, or is that not a need? So it could be maybe helpful to at least have that breakdown for the legislature at some point.
Go ahead.
To clarify, you'd like a breakdown comparing the bill, or you'd like a comparison of the EPA requirements for both?
I guess the changes made that are being made in the bill and designating, change one, maybe have a citation to the specific EPA regulation or statute that require the change is coming from, or to designate the change as more of a quality of life KDA change. Having that listed out could be helpful, just so the legislature has a clear picture of these are the changes that are needing to be made for the state to retain its primacy.
I appreciate the clarification. Thank you.
Would that be possible in the coming days?
I can work on putting that together for you.
Okay. Probably what we'll do is, committee is look at working this bill early next week, just to give plenty of time. Also, the other conferees that we invited back today, and also Ms. Hessong is here for Farm Bureau. If you also want to, once we get more questions, I would like for all of you, if, I guess Claudia's still here, right? Okay. So those of you that testified also, if you want to comment on what you've heard so far, again, folks, they're committee, they're also here to answer your questions. So just wanted you to be aware of that. But I do want to call on you then and maybe respond if there's some things maybe, especially how I'm thinking farmers, corn growers, and so on. So just want you to be aware of that. I'm not calling you yet. No, I'm sorry. Just make sure you were hiding behind Mr. Hancock there. So Representative Gardner.
Thank you, Mr. Chairman. And I just wanted to say that what the revisers request I see as very important for me, because at this point I do not see clearly which of these revisions are driven by fulfilling requirements for the EPA, and how many of these changes are what we felt was good. For instance, the level of fines being a maximum of $5,000, which is a significant jump from where we've been. And secondly would be, as the revisor just mentioned, applying chemicals on, not for compensation, on neighboring properties. And because in my community, that is very important. If we're going to, we either have to, if we continue as we are now, we either have to violate the law or we have to discontinue our community control program. And so if those things could be delineated, whether or not those are, okay, the other thing is I don't want to torpedo this bill because I sure don't want the EPA driving in my driveway and trying to figure out if our little community control program is legal or not. I would a lot rather talk to someone from the Department of Agriculture any day. And so, but I do have concerns about the level of fines and the record-keeping requirements and the testing for keeping a license and the ability to spray or apply on neighboring properties.
All right. Okay, Representative Carlin.
Thank you, Mr. Chair. A couple of things come to my mind in these conversations. One, I heard Representative Gardner say little community control program. And I've been wondering that myself. When you say little, I thought, that's what I'm wondering. What's little? Okay, I grew up on a farm, and if the neighbor wanted to spray our driveway for bindweed, and we went and milked these cows one day, that was a kind of a little thing. When does it get too big? And I don't have a position on this. I'm learning. I remember a friend of ours who did a lot of bartering, and at that time I learned that you're supposed to turn that bartering in as income. There's a reporting. Tell me about that. Somebody, Kyle, I don't know, somebody who knows about the law on bartering. I mean, if it's me and I'm milking their cows and they're spraying my driveway, I don't think we have a problem. But if it's bigger, when is it bigger? And what do we need to define those things? Is there already a definition on that in that? And that's, I think, would help with Representative's concerns about the laws and the rules. Do we have them already? If I'd studied this at length, would I have found those things?
For bartering?
Well, what's little, what's big? Is 5,000 acres little or big? I don't know. I don't know what the federal government's trying to do, what they're trying to prevent. Remember the farmers that had grapes that got sprayed a few years ago, and we had quite a conversation in here. None of you were here, but we had quite a conversation in here about somebody sprayed their grapes and killed their grapes, and it was drift and it was inappropriate use of, and that's when I learned all I know about spraying. So I know that we've had that experience in Kansas, and we should protect people from that kind of thing. But what's the fair kind of, I don't know what's fair, and I don't know what's big and what's little.
All right, well, let's maybe start now. Let's go to Ms. Hissong from Farm Bureau, if you want to come up first. I'm going to call Mr. Stuckey after this, but do you want to comment on that from a Farm Bureau policy standpoint, or how you bring that concern about the barter, and if Farm Bureau has made any sort of definition about what Representative Carlin said?
Yeah, thank you, Chairman, Committee, Claudia Hissong, on behalf of Kansas Farm Bureau. We have not defined what that barter language should look like. Our members have talked about producer, for producer. We have not expanded upon what the specifics of that barter language. So we've looked at it from a producer to producer, conveying goods between each other. And so that has been it.
While you're there, any other comments that you have based on what you've heard of the concerns or the questions from committee members today?
Yeah, this was exactly the conversation we were hoping to spur around this bill. We know it's a very large piece of legislation. There's a lot of topics in it. Appreciate all the comments regarding barter language, and I think the committee has done an excellent job pulling those out. So we've really appreciated the discussion today and are supportive of the direction that I think the committee is heading, and continue to support that barter language being in there.
Representative White.
Thank you, Mr. Chair. Can we somehow include the barter language complementary? I sprayed a neighbor's pasture last year. I was afraid to take money, so I said, yeah, it's on me. So barter and complementary may not be the right word. Free, neighborly is how I would say it.
That might be a question for KDA. I believe the bill is written just barter for services, so I might turn it over to KDA of if that would come into complications with commercial applicator license.
Okay, very good.
Thank you.
Thank you.
Other questions from Ms. Hissong? Okay, stand by, but
thank you.
We'll do that. Thank you. Mr. Stuckey, a lot of discussion on small private applicators and so on, but from Feed and Grain and other things, comments, concerns, or just from what you've heard today from our committee?
Yeah, Randy Stuckey, Kansas Grain and Feed Association, Kansas Agribusiness Retailers Association. So good conversation today. And we obviously had extensive comments the other day on a lot of these points. And just kind of segmenting them out. The barter issue, I think it asks us to take a step back and maybe look at what we're trying to accomplish here, outside of the EPA primacy issue. And a lot of what we're talking about really is, I think maybe Representative Carlin brought it up, was the level of degrees here. Because this law applies to, you're walking on your neighbor's property with a backpack sprayer, applying as well as the largest application that you can conceive done through barter. And that's why it's kind of a square peg in a round hole at times, depending on how it's being applied. It's at this point that we have to look to KDA to say, is there a way, if the intention of the legislature is to retain the barter concept, right? And there's questions here about, is it applicable, or should it be applicable to all degrees of application? Or do we really want the largest of applications, which should only be done, certainly if it's restricted use pesticide, by those that know what they're doing, are certified in those applications, be it commercial or private? I would argue that should be the case. That maybe it's appropriate to remove the barter system for the largest of the applications. Arguments could be made on the other side of that as well. But if we could separate that question down and allow the KDA to do that, which you would do through language in the barter section of this bill, somehow splitting that issue. And they do this in other areas. The pesticide dealer's license is X amount if you only are a dealer for a small amount of pesticides per year. The fee is much larger. It's a different license if you're a commercial dealer for large retail. So it's not a new concept. If we can address these issues in that manner, then at this level, I think that might make sense. Otherwise, you're saying, do we keep it or do we not? And there's going to be conversations on both sides of that coin. Similar to the civil penalty piece. And we stood here last week and said, we didn't think it was necessarily appropriate for a $5,000 maximum civil penalty for the folks who work for a living through commercial applicators or the private applicators. Here we're talking about the farmers themselves. Farmers come in different degrees, right? You have folks that have 10 acres and maybe they want to apply to their own, hobby farm. That same private applicator certification, through definition, extends to the largest of the private landowners, who themselves or their family or their hired man applies pesticides, restricted use pesticides on their own property. So again, that civil penalty piece may not be appropriate. Certainly $5,000 isn't appropriate for, we think, the person who's working for somebody else and applies pesticide and happens to drift on another neighbor's property, or they fail to wear all the personal protective equipment, the PPE that's required by the label. A lot of this will be spelled out within the KDA regulation, but it's at this stage that the legislature has to say, is $5,000 civil penalty appropriate for that? And while it might not be for most of those applications, it might very well be for some of the largest private applicators. For that reason, we've met this morning with KDA and we said, without having had buy-in on this language 6 months ago, which we would have preferred, I think everybody would have preferred before it went to the EPA and we were kind of put in this position. At this point, would we be comfortable as an association with that $5,000 maximum penalty, working with the good people within KDA to know that when they set the actual civil penalty amounts for individual types of violations of the Act, that those amounts will be set at a graduated scale depending on the type of violation, the type of applicator, and whether it was a repeat violation or other aggravating or mitigating factors. Those are things that KDA can do within regulation. We would take it on good faith that they would allow us to work with them on putting those civil penalty structures together in a way that does make sense and is reasonable for the folks that I was talking about last week. We've never argued that $5,000 was necessarily the maximum penalty was unreasonable for a business at times. But is it appropriate going forward for certified applicator employees and private applicators? Not generally, but we agree to work with KDA in the regulatory process and setting out those graduated penalties if the legislature would agree to the $5,000 penalties that are set forth in this bill. Now, it's your decision on what to do with that. We're just saying, giving you our position on it at this point. Now, there's other pieces in the bill that we had proposed amendments as well. I think we've come to an agreement on the rest of that language. I think that's what we had to cover, Mr. Chairman, but if there are any specific questions, I'd be happy to talk to those as well.
Just a second, I guess I'll get a question today. So let's go back and talk about, you know, the insurance or the surety bond or line of credit. Have you had a chance to talk with your members as far as, because possible liability insurance would be more expensive than maybe their business plan works, or they are at a size where a letter of credit works to cover their liability, these bonds, what, because I would assume it's a matter of economics, and would this put undue pressure, maybe hurt or cause folks to discontinue their service and could cause, you know, unintended consequences in some parts of the state?
So, yeah, I knew there was a third one I was trying to get to. It was the civil penalties, the barter, and then this financial responsibility or proof of financial responsibility. Outside of the liability insurance piece, the other 3 or 4 ways that a person can provide proof of financial responsibility, they have those $6,000 caps along with those types of that are set out in statute today, which means they've been there a long time because $6,000 is not appropriate for any kind of liability coverage, and that's what this is supposed to be. If you harm somebody else or their property, that $6,000 is there to show that you have money on hand to cover that damage. Now, if you're a commercial applicator today, a business, and you're carrying liability insurance, and you are to be able to do that, look, if you're a commercial applicator applying ag chemicals, if you drift onto a neighboring irrigated corn section, you're going to need at least $250,000 liability insurance off the bat. And so I would hope that of that list that KDA gave you a little bit ago about the other types of financial responsibility that exist today, the folks that have those instead of liability insurance, I would certainly hope that those were non-agricultural applicators, lawn and garden, people like that, residential turf maybe, where your exposure may be a little more limited. Still, $6,000 is nowhere near what you needed to be, where you need to be if you apply to something, say a neighboring homeowner, and then you kill their cat or dog, right? I mean, or somebody, if you don't give notice that you've made the application. These things happen routinely. That's why this proof of financial responsibility requirement exists. If they're going to be retained, we would certainly hope that if not in statute, either pull out the $6,000 in the statute and require it to be put in regulation, or think about what would be more appropriate for the current day's need for financial responsibility. We're saying $250,000 likely for agricultural liability for the insurance piece. Just something to think about and look at, but certainly much more than $6,000, which is woefully inadequate because it's been there for decades.
Representative Jacobs.
Thank you, Mr. Chair. Going back to your organization or your groups and then the department making the rules and the regs, I think that was kind of one of my concerns. I think we as the legislative body should be within that realm too, helping to craft some things just so that it's not coming back to us or coming to the people and saying, well, here you go, here's another surprise for you. So that's my concern.
Yeah, I think this was a situation that was really put on everybody because it was a top-down from the EPA, but certainly we wouldn't disagree with more notice on the front end of this bill.
Other questions? All right, thank you.
Thank you.
Up next, let's go to Ms. Stafford with Co-op Council. Anything that you have to comment of what you heard or other things that we need to be aware of in the committee?
No, we don't have specific language that we want changed. Thank you. The Co-op Council does not have specific amendments that we want changed. We do see the value in looking at this a little bit slower, like Randy has said, and not necessarily barter language, but fines would be a concern. It would have been nice to be able to be at the table when the
department was putting the plan together before it went to the EPA, but we do know the timeline and the restrictions that they're under. So if we have a little bit more time, which it seems like we do with the EPA, to relook at this, resubmit if we need to. Hopefully, the amendments we make may not be required to resubmit. Then that's what the Co-op Council would like to do.
All right. Any questions? Seeing none. All right, Mr. Hancock, you're up. From Aerial Applicators, you had just a short time, but you're kind of an addition now to this plan. The way I understand it, it's new language to putting your group into this. So, any other thing that we need to learn that you maybe was in testimony last week?
Thank you, Mr. Chairman. Steve Hitchcock with Kansas Agricultural Aviation Association. Just a couple of things to echo what Randy said on the proof of financial responsibility. A few years ago, when this was discussed in 2020, and we even had a discussion early on in my time here about 2013 or 2014 about the practicality of the proof of financial responsibility framework. And 10 years ago, we defended keeping that because we had enough aerial applicators who were using the variety of proofs of financial responsibility, particularly when we discussed it at that time, the use of bonds by an applicator that was coming in from Nebraska or Colorado to spray during an insect invasion, who didn't want to pay an insurance fee for an entire year with an insurance company, but set up a bond for the time during June that he was spraying in Kansas or something like that. In the most recent reconsideration of that, I guess it was 2020, talking to our old timers who were around when that language was written, they said that time has kind of passed. The majority of our applicators are using the certificate of insurance, and they said that one of the reasons for the variety of proofs of financial responsibility, to quote or at least paraphrase, was that if a state was an insurance certificate only state, that tended to attract lawyers. And that was one of the concerns. I think in this day and age with liability the way it is, I think that time period has passed. I think there are a sufficient amount of lawyers that they can make it to all states, and that's the reality we live with. So from our perspective, that proof of financial responsibility is an issue that is kind of faded in our consideration. The record keeping and listening to the discussion of private applicator record keeping, my organization is made up of people who are commercial applicators. Record keeping is a part of their life, part of doing business. They accept that as part of their life. They gripe about it. They complain about nitpicky things and confusing things. And I think there's an effort here to streamline the statement of service. And I looked and I didn't find it in my copy of the bill. I may not have run that page off. The invoice that our applicators provide to the customer is essentially a summary of their record keeping. Their record keeping about time of application, about wind and weather, and various things related to the label. Working for these crop dusters as a paperwork person, I realized very early on that the reg number, the EPA reg number on a chemical bottle is different than the establishment number. The establishment number is where it was manufactured. The EPA reg number is the magic number that dang well better be on that statement of service. For that reason, the record keeping for commercial applicators is part of building the statement of service. If you're a private applicator, you don't have a statement of service that you're handing to a customer. So you don't have the additional incentive for the record keeping. Just to be a little bit contrary, one of the things about record keeping is that it does provide a safety net for the applicator, whether they're a private applicator or a commercial applicator. An example that I can think of the top of my head, damage to a person's ornamental trees around their farmstead. The first thing that came to their mind was, a week ago, there was a large, noisy airplane spraying the pasture across the road. And that's one of the things we always warn our members about. They're visible, they're loud, they're the first thing people think of if they see damage. There was an airplane in the area. The records that that sprayer kept were examined, and they were found that whatever he was spraying was not, the residual was not what was found in those trees at the farmstead. So his record of what he was spraying eliminated him as the cause of the problem. Later on, it was found that a county road crew was using up some of the jugs of things that were in the back of the county shop and spraying along the roadside. And they had not kept records. And so the record keeping that the commercial applicator did was what saved him from a high degree of liability. Just for the conversation on private application and record keeping, we are all dealing with the downhill side of the dicamba problem from a few years ago. Kansas had a problem. I'm in contact with a lot of Missouri applicators. Missouri had an issue 10 times what we had. And part of the problem they had with sorting things out was the lack of record keeping. And so that's part of the push is, and the motivation for that comes from those situations. Those are the things I just wanted to bring up. As the chairman said, this aerial category, as I mentioned the other day, we see as a necessary and positive step. It puts us in sync with other states in terms of continuing education, in terms of reciprocity. It puts us in a position to hopefully integrate unmanned systems in a way that is safe and practical and logical. Thank you, Mr. Chairman.
Thank you, and I apologize. I called you Hancock rather than Hickok, so that's
Mr. Chairman, I'm sure your name has been mangled as much or more than mine, so
that's probably so. Well, almost, other than the good representative from Topeka.
Yes.
Okay. We do have one more, and I guess I'm saving Taylor Williamson from Kansas Corn to be last because of the farmers, the producers he represents. So, Mr. Williamson, again, want to. There's a lot of things that were discussed, and again, from a producer, from an association of corn growers standpoint, from what you heard today or anything else, maybe I know your testimony was rushed last week, so floor is yours.
Yeah, no, I appreciate that opportunity, Mr. Chairman. And to be clear, none of us want additional burden put on us. None of us want additional training requirements, any of those things. But part of what we're doing is maintaining the primacy, and I know that's been stated over and over. Now, we would be supportive of maintaining the barter language. I think we'd be supportive of all the things that Randy said. That's kind of the benefit of going after Randy, is he gets to state all of the really good stuff, and we can just say we back him, because we do. From a grower perspective, some of these things, when we start talking about federal overreach and mandating to states and things like that, it gets a little complicated. I want to point out a lot of the commodity groups are currently in litigation with the state of California for something that's not dissimilar to what we're talking about right now. California set up different regulations for how they want to approach things like glyphosate. And it's our opinion, and there's a lot of opinions of a lot of different commodity groups that they violated the Federal Insecticide, Fungicide, and Rodenticide Act, which states federal preemption of state laws. That was something put into statute by Congress, and a lot of commodity groups are suing the state of California for changing the glyphosate laws. Now, this is kind of the opposite direction. California wanted to go more strict. We're wanting to, and so the idea of not abiding by EPA would be to be less strict. But I think it's a little bit of a cautionary tale that, you know, commodity groups are not the only ones suing people out there. There are environmental groups. There's a lot of groups out there that do sue. So I don't know what it would actually look like. I don't know if it's possible to make that same federal preemption case against the state of Kansas, but I do think that is possible, and would be a word of caution. Again, I don't think any of our farmers really want additional oversight. They don't want additional requirements. They don't want a lot of those things. But at the end of the day, sometimes we have to take a step back and maintain the. I think in one of my updates, I called it the bad guy we know as opposed to the bad guy we don't know. We really do love you, KDA. But yeah, I think we would stand open for a lot of those amendments, and it's something that our growers really put a lot of value in, is having the governance be far closer to local than it is from DC.
Questions for Mr. Williamson? Saying none, thank you. And also, we did have an open discussion for conferees, but I know we've had a lot of discussion about insurance, financial lines of credit, so on. We do have Lori Brown here. So, Lori, if you would, Larry, I'm sorry, I know. Larry, I'm sorry.
He was tall. Thank you, Mr. Chairman and members of the committee. I am Larry Ann Brown. I do represent the American Property Casualty Insurance Association. We really didn't have much of a dog in these weeds, but we do just sort of wonder why you would want to eliminate an option for the surety bond. It is a cheaper option for your all's constituents. I understand from the Department of Ag there's not a large take-up of those options, but it is just something that you all might want to consider leaving as an option. To Mr. Stuckey's point about the level of the $6,000, we'd be willing to look at raising that if you wanted to make it more reasonable. I'm just here to just make sure that you all understand that when you take away options for some of your constituents, you might hear from them.
Very good. Question, Ms. Brown?
Thank you, Laurie Ann, for speaking up on that. I just
Representative
realized.
Carlin. Go ahead.
Pardon me? Did you say something wrong?
No.
Did I?
You just started talking, so go ahead.
You
Go
pointed.
ahead.
He did this.
Oh.
In marriage, that's okay. You go ahead. I don't know what it is here.
Is she saying she's your work wife?
No. Sorry about that. I remember dropping a baby bottle when I handed it to my son while I was holding his child, and I just knew he would take it, but it wasn't my husband, and he didn't know what to do with it. He dropped it. So those kind of signature.
Where are we?
I don't know. We're lost.
Go ahead.
The question I have is, I just got a new policy for my homeowners, and we added something for my farm, which is 80 acres. No big deal. But there was a liability insurance that I didn't have, and I got sold, and it wasn't very expensive. And so can you talk about what the cost would be of something like that for small independent people? You know, I think we're still talking about big and little, what they are, but do you have can they do it outside of their homeowners insurance, or would that be the way they would get it?
I really couldn't answer that. I'm in the exact situation that you're in.
Yeah,
I have a
okay.
small 77-acre farm, and I just added a little, actually just the description under my homeowners and then under my umbrella. I don't know how much extra it cost. I don't think it was much.
Okay, then the question I really have is, would that cover incidents like these accidents?
I don't know for sure. You'd probably have to check with your agent to make sure that that's covered. Mine, I think, is mostly, people like to hunt on mine.
Yeah, if they
So
get
I have,
hurt
I
there.
have coverage in case someone gets hurt or injured.
Okay, thank you.
Very
Thank
good.
you, Mr. Chair.
Thank you.
Thank you.
Thank you, Larry Ann. Sorry. My wife's name is Lori, so it's, you know, one of those deals. And probably so with the mics off, but no, I'm just kidding. Okay, anything else from the committee? I know we probably still have a lot of information again today to kind of go over. I would suggest read the bill. If you want to seek out some of the conferees for any other concerns you have. I do want to bring up Ms. Olson right quick before we wrap this up. Okay. Not necessarily put a capstone on, but just kind of get that 3,000-foot level. What happens if we don't work the bill? What happens if it doesn't go anywhere? What does that mean for Kansas farmers and applicators?
If we take no action today, our current laws would stay the same. What we don't know is what steps the EPA might take since we have deviated from our implementation plan. As far as the implementation plan being, we've made the proposed changes. The next step is securing these changes to the statutes that we believe we need in order to comply within the box that the EPA has outlined for us. So there is some unknown. I don't think, this is a complete opinion, I don't think that there would necessarily be swift action taken by the EPA, but I could be wrong by that. But we don't know what would happen directly.
So if something is done, maybe it's a little bit lighter than what we have right now, EPA could come back and say, well, here's 6 different things. Would Kansas, in a sense, still be in compliance? We could come back next legislative session and continue to work. Does that show a good faith to EPA that we're all trying to work through this? Because and are we in the same kind of spot as other states then right now? Is this going on in other states as we speak?
So yes, each state, once they submitted that plan, has varying stages that they have to go through for implementation. So we are in similar state, in a similar status as other states. I can't speak exactly what they have. They have different rulemaking requirements by each state or authority's guidelines. In regards to the EPA, if there are changes made, we would do our best to take them back and say, this is what we've been authorized for. And that would likely, depending on what those changes are specifically, that may result in us needing to seek a modification approval from the EPA. And at that time, we would then start the process over, and depending on what they say based on those changes.
Last question then. I remember, if I remember right from earlier testimony or earlier conversation, that this is a 7-year process basically for implementation, that it will be done by 31. So I guess the sub-question to the last question is this going to be an ongoing thing every year? Will we have to tweak it now every year moving forward, or once it gets, quote, approved by the legislature, that's it?
So our plan is to have a multiple step implementation program. Part of that is because there's statutory changes that are required. We would like to build out the rules and regulations that are then needed based on any of the statutory changes. In the meantime, the licensing periods that are currently held by the commercial applicators, the private applicators, in order to transition everyone to the new set of requirements based on their licensing needs, because of those times of period, would be extended through 2031. If there were changes up front at the statute level, that may delay that implementation plan. It will just depend on what those amendments may be.
Okay. Representative Schlingensieben.
Perfect. Thank you, sir. So if to summarize, I guess the revisor asked for a list of things that required some clarification, or at least where amendments might be possible. So I'm assuming that the points that you all brought up on both sides of the table here, we could then talk about what sort of modifications are necessary and see where that goes.
I believe that's, I would like to be able to do that. If KDA provides that, we would like to provide it to committee.
We'd be happy to provide that, and we might just, if it's okay with you, Chairman, work with Kyle. I know there's a couple revisor tweaks, but we'll try to group everything as far as what we believe pertains directly to the EPA, some additional things that we had proposed changing that may or would likely not impact the EPA's state plan approval.
Fair enough. Very good. That's it? Okay. Again, thank you, committee, for in the indulgent, but I think we had another good listening session, I hope, and those that had questions or concern not only got the merit, but maybe feel a little bit better moving forward. I think we still have some more to do before we work the bill or however we move forward. I'll put it that way. A couple of things. You should have in your email the multi-year flex account report from the Division of Water Resources from KDA, Ag Marketing report from the Division of Ag Marketing within KDA, and the Conservation Reserve Enhancement Program report from the Division of Conservation. We are meeting tomorrow. The hearing will be on House Bill 2564. That is the Farm to Food Bank program, which I assume you've already received emails on, probably from both sides. So it may be interesting tomorrow. Also, House Bill 2608, the Poultry Disease Control Act and fees. So we'll do those hearing on both those bills tomorrow. Anything else for the good of the cause? Saying none, we are adjourned.